Chapter 53 Child Support 1. Child Support Guidelines. Federal and Provincial Child Support Guidelines. Guidelines are regulations that prescribe the quantum of child support based on the number of children and the payer's income. The stated objectives of the guidelines are to set a fair standard of support so that children benefit from the parents' financial means after separation, reduce conflict between parents by making the calculation of child support more objective, improve efficiency and encourage settlement by giving courts and parents guidance in establishing child support, and ensure consistency in treatment of parents and children in similar circumstances. Federal Guidelines. S1. Ontario Guidelines. S1. The federal and provincial guidelines are identical regulations, and throughout this chapter guidelines will be used for both too. Jurisdiction 2.1 The federal guidelines. If the parents are divorcing or have divorced, a child support application is determined under S15.1 of the Divorce Act by applying the guidelines, which are regulations to that act. A parent may seek child support in a province in which that parent has resided for 1 year as part of a divorce proceeding. S3. 1. A former spouse may make a child support application in a province in which the former spouse is ordinarily resident at the start of the proceeding or if both spouses accept the court's jurisdiction. S4. 1. B. 2.2 The provincial guidelines. If the parents are not divorcing or were not married, a child support application is determined under S33 of the Family Law Act FLA by applying the guidelines, which are regulations to that Act. 3. Calculating guideline support 3.1 Standing 3. 1. The claimant under the Divorce Act. Only a parent who is a married spouse or former married spouse may make a child support claim. SS 15.1. 1. And 17. Under the FLA, a parent or dependent child may apply for child support. S33. 2. Also, a government agency providing benefits for a child or in receipt of an application to provide benefits for a child may apply for a child support order. S33. 3. The government agencies are the Ministry of Community and Social Services, a municipality, a district social services administration board, or a delivery agent under the Ontario Works Act, 1997. 3. 1. 2. The Divorce Act restricts eligibility for child support to a child of the marriage. S2. 1. A child of the marriage means a child who is under the age of majority and has not withdrawn from the parent's charge, or is over the age of majority but unable because of illness, disability, or other cause to withdraw from their charge. Previously, the FLA restricted eligibility for child support to an unmarried child who was a minor or was enrolled in full-time education and, if over the age of 16, had not withdrawn from parental control. S31. This restriction was found to be discriminatory contrary to S15 of the Charter of Rights and Freedoms. The court reading in the Divorce Act definition of eligibility for child support. Coates v. Watson. Currently, eligibility for child support is the same under both the Divorce Act and the FLA. Generally, the obligation to maintain a child extends through the completion of a first post-secondary degree. Witten v. Witten. Nothing in either act limits the obligation to one degree, and in an appropriate case, the court may extend support after consideration of relevant factors including the financial circumstances of both parents and the child's academic performance, and family education expectations. Oates v. Oates. Subsection 2. Of the Divorce Act states that for the purposes of the definition of a child of the marriage, a spouse or former spouse who stands in the place of a parent may also be included. To determine a non-biological parent's financial responsibility for a child, the court must weigh a number of factors on an objective test, including whether the child participates in the extended family in the same way as would a biological child, whether the person provides financially for the child, whether the person disciplines the child as a parent, whether the person represents to the child, the family, or the community that the person is responsible as a parent, and the nature or existence of the child's relationship with the absent biological parent. Once a parent-child relationship is established, it cannot be unilaterally terminated by the parent. Chartier v. Chartier. The FLA definition of child includes a person to whom a parent has shown a settled intention to treat as a child of the person's family. A settled intention is determined on an objective test based on conduct, including consideration of the same factors as under the Divorce Act. Parentage is determined pursuant to Parts I and II of the Children's Law Reform Act. A person may become a parent of a child by adoption, as the birth parent, as the biological parent through sexual intercourse, or as the spouse of a birth parent of a child conceived by assisted reproduction or by insemination by a sperm donor, a person is presumed to be a parent, subject to challenge on a balance of probabilities, if that person was the birth parent's spouse at the child's birth, married to or living in a conjugal relationship with the birth parent in a relationship ended by death, divorce, nullity, or separation within 300 days of the child's birth, certified as the parent of the child at birth under the relevant legislation in a Canadian jurisdiction, found to be a parent by a court of competent jurisdiction outside Ontario. A person who provided reproductive material or an embryo for assisted reproduction is not a parent unless otherwise recognized by the statute. A surrogate is not a parent pursuant to consent or relinquishment under the statute. 3.2 The residential arrangement. 3.2 1 Primary residence. If a child resides primarily in one parent's home for at least 60% of the time, the other parent must pay guidelines support based on the child support table. 3.2 2 Shared custody. If a child divides time between the parents' homes to spend more than 40% of the time in one and less than 60% of the time in the other, the court has the discretion to depart from the table amount, pursuant to S9 of the guidelines. There is no presumption in favor of either the table amount or a reduction of the table amount. The court's discretion is determined by 3 statutory factors: the set-off between the amount each parent would pay applying the table amount, the increased costs of the parenting arrangement, and the condition, means, needs, and circumstances of each parent and child. The court will also consider the importance of ensuring the children do not experience significant variation in standards of living between the two households. In a variation application of an existing parenting arrangement, the court will consider a parent's reliance on receiving the table amount of support in establishing that parent's household continuo villanelli continuo. 3.3 Split custody. If custody of the children is divided, with one or more residing primarily in each parent's home, child support is calculated as the set-off between the amount each parent would pay for the child or children in the other parent's care applying the table. S8. 3.3 The number of children. The table sets the quantum of support based on the number of children. The amount payable is not per child but a global amount for all the children in the household. 3.4 The ages of the children. The court has discretion to depart from the presumptive table amount for eligible children over the age of majority if the court finds that amount inappropriate, having consideration to the financial means, needs, and condition of the child and the parents. S3.2 Relevant considerations are the child's ability to earn income, the availability of loans, scholarships, and bursaries if the child is enrolled at a post-secondary institution, the child's performance at school or in a post-secondary institution, the child's full-time attendance at school or the reason for part-time attendance, and the child's budget. 3.5 The payer's income. The guidelines prescribe a method to determine a payer's income. The starting point is the payer's total income shown on the payer's income tax return as adjusted in accordance with Schedule 3 of the guidelines. S16. Either party may ask the court to find that the payer's income differs from that calculated under S16. The parent asking a court to find a different income bears the onus of proof. A court may find a different income if the amount calculated under S16 is not the fairest determination in light of income fluctuations over the preceding 3 years or non-recurring income or losses. S17. A court may include in a parent's income all or part of the pre-tax income of a corporation in which the parent is a shareholder, director, or officer and may adjust that pre-tax corporate income to add back amounts paid in salaries, wages, or management fees to non-arm's length parties. S18. The court may also impute income to a parent. S19. 1. In a number of situations including but not limited to intentional underemployment, exemption from payment of income tax, payment of tax at an effective rate lower than that in Canada, diversion of income, failure to reasonably utilize property to generate income, failure to make proper financial disclosure, a situation in which a significant portion of income is paid from dividends or capital gains, or unreasonable deduction of expenses from income, reasonableness not being solely governed by the standard applied in the Income Tax Act, guidelines. S19. 2. If income is imputed, the court may adjust the amount by increasing it to take into account income tax since the table is based on gross taxable income. 3.6 Financial disclosure. Each parent has an obligation to make financial disclosure under S21 to permit the determination of income for guidelines purposes. The disclosure is for the 3 preceding years and includes income tax returns, notices of assessment and reassessment, and statements of earnings for employees, where a parent is self-employed. It also includes financial statements of the parent's business or practice, a breakdown of salaries, wages, and management fees to non-arm's length parties, and financial statements of a corporation controlled by a parent and of any trust of which the parent is a beneficiary. If the payer parent refuses to make voluntary disclosure, then the recipient parent must commence a court application to obtain orders to compel financial disclosure. In an appropriate case, a parent may apply to a court for an order to compel disclosure directly from a third party, but only on notice to the third party, who may defend against such disclosure. It is not possible to obtain financial disclosure from governments or employers in the absence of the payer parent's consent to the release of personal records and information or a court order to compel such release. If a payer parent breaches court orders for financial disclosure, the recipient parent has access to remedies for breach of a court order, including striking the delinquent parent's pleadings or seeking a finding of contempt for the breach. 3.7 Income over $150,000. If the payer parent has income of over $150,000 per year, the court has the discretion to depart from the presumptive table amount if the court finds that amount inappropriate. As for the parent seeking an order that deviates from the table amount bears the onus. However, the court will not easily depart from the presumptive table amount. Income must greatly exceed the $150,000 threshold before a court will adjust the table amount. Francis v. Baker. Courts have ordered table support as high as $11,173 per month for a 4-year-old child. Tauber v. Tauber. 3.8 The table amount. The table amounts reflect average costs for children's expenses. The recipient does not pay tax on the child support received. Each province and territory has a separate table. The applicable table is the one for the province in which the payer is ordinarily resident at the time of the application or at the time of determination if the payer has moved. If the payer resides outside of Canada, the applicable table is the one for the province in which the recipient parent ordinarily resides. S2. 1. 3.9 Special or extraordinary expenses. In addition to the table amount, a court may order the payment of all or a portion of an itemized list of special and extraordinary expenses, including child care costs incurred as a result of the parent's employment, illness, disability, or education or training for employment, extraordinary extracurricular expenses, and extraordinary primary or secondary education costs. The guiding principle is that the court will apportion the expenses between the parents on a pro rata basis after taking into account the contribution, if any, from the child and any related subsidies or tax deductions. S7. Extraordinary expenses are defined in S7, 1.1, of the Guidelines. These are expenses that exceed the amount the requesting spouse can reasonably cover, taking into account that spouse's income and the monthly child support payable, or expenses that a court considers extraordinary in light of the amount of the expense related to the requesting spouse's income, including the monthly child support payable, the nature and number of the educational or extracurricular programs, any special needs and talents of the child, the overall costs, and any other similar factor the court considers relevant. For example, if the payer parent has income of $75,000, the recipient parent has income of $50,000, and the S7 expense costs $2,000 a year, then the calculation of the parent's pro rata shares is as follows. Combined income, $75,000 plus $50,000 equals $125,000. Payer parent's pro rata share, $75,000 percent $125,000 equals 60%. Recipient parent's pro rata share, 100% 60% equals 40%. 60% of $2,000 equals $1,200. 40% of $2,000 equals $800. The payer parent is responsible for $1,200 of the expense, and the recipient parent is responsible for $800. 3.10 Undue hardship. A court has the discretion to award an amount different from the table amount if the court finds that a parent or child would otherwise suffer undue hardship. S10. The guidelines identify a non-exhaustive list of circumstances that may cause undue hardship. These include a parent with unusually high access costs, a parent with a legal duty to support any other person, and a parent with unusually high debts reasonably incurred to support the family before the separation or to earn a living. Before exercising its discretion to depart from the table amount, the court must make a finding of undue hardship, and the applicant must demonstrate that the applicant's household would otherwise have a lower standard of living than the other parent's household. The guidelines provide a standard of living test in Schedule 2. Commercial software is available to perform the calculation. 3.11 Special provisions in past orders or agreements. The court has the discretion to award child support that departs from the table amount if a pre-existing order or separation agreement contains special provisions concerning the parties' respective financial obligations or the division of property that directly or indirectly benefit the child, but only if the application of the guidelines would result in an inequitable award. Divorce Act, S. 15.1. 5. FLA, S. 33. 12. Under S. 56. 1.1. of the FLA, a court may disregard any provision of a domestic contract for child support if the amount is unreasonable in light of the guidelines. 3.12 Reasonable arrangements. The court may award an amount that differs from the guidelines if the parents have consented to it and the court finds that reasonable arrangements have been made for the Child Support. Divorce Act, SS 15.1. 7. 8. FLA, SS 33. 14. 15. However, where child support is payable from public money, these arrangements cannot provide for an amount less than the guidelines amount. 3.13 The form of the order under the guidelines. The court usually awards periodic support. A court may order lump sum support, secured support, or another form that is reasonable in a particular case. Subsection 15.1. 4. of the Divorce Act permits the imposition of terms, conditions, or restrictions concerning the award. Under this provision, a court may order that child support bind the payer's estate. Subsection 34. 4. of the FLA provides that orders under that statute are binding on the payer's estate. A child support order must include the name and birth date of each child, the income of any parent whose income is used to calculate the support, the amount of support, the particulars of any S7 expenses, and the date or dates of payment. Guidelines, S13. It should include standard terms providing for enforcement by the Director of the Family Responsibility Office. It should also provide for annual financial disclosure pursuant to S24.1 of the Guidelines. 4. Retroactivity. A court may order child support payable for a period preceding the commencement of the application. The parent's obligation to support their children in accordance with the parent's incomes is a right of the children independent of any statute or order. To decide if a retroactive award is appropriate, a court will balance fairness to the child, flexibility, and the parent's interest in certainty. The court will consider such factors as the reason for the delay in making the application, the conduct of the payer, a child's present and past circumstances, including need at the time that the change occurred, and whether the retroactive award will cause hardship. If the court finds that a retroactive award is appropriate, the general rule is that the new order should be retroactive to the date that the requesting spouse gave effective notice to the payer's spouse by raising the issue. The retroactive award will be limited to 3 years past unless the court finds blameworthy conduct by the payer's spouse. DBS v. SRG, LJW v. TAR, Henry v. Henry, Heemstra v. Heemstra. 5. Variation. A final order under either the Divorce Act or the FLA may be varied if either parent can demonstrate a material change in circumstance that, if known at the time, would have likely resulted in a different order. Willick v. Willick. The variation must be sought in the court that granted the original order. If a support order or agreement has been assigned to a person or an agency, the parties are required to serve the assignee as if the assignee were also a party. To determine if an order has been assigned, a party or the party's lawyer may complete and send a confirmation of assignment form to the Confirmation of Assignment Unit of the Ontario Ministry of Community and Social Services. 6. Ongoing financial disclosure under the guidelines. Upon written request, a parent must make ongoing financial disclosure annually after the granting of a child support order. S25. Where child support is payable by a written agreement entered into in or after 2010 and the support amount is determined based on a parent's income or financial information, that parent must make annual financial disclosure within 30 days of the anniversary of the agreement. S25.1. 7. Child Support Calculation Service. The provincial government may administratively calculate child support where there is no order or agreement for support, as long as both parents consent. The child support calculation must be in accordance with the guidelines, based on the information provided by both parents, and will be enforced by the Family Responsibility Office. Either parent may apply to have the child support recalculated after an initial calculation or a child support order or agreement. On a recalculation, the administrative authority may deem a parent's income if that parent fails to provide income information. 8. Interjurisdictional Support Orders Act, 2002. The Interjurisdictional Support Orders Act, 2002, ISOA, provides a regime for an applicant for child support to obtain orders against a payer parent in a reciprocating foreign jurisdiction. The list of reciprocating jurisdictions is found in the regulations to the ISOA. Each reciprocating jurisdiction has a designated authority to process these applications. In most cases, a support applicant within Ontario sends the application to the designated authority in this province, who forwards it to the designated authority in the reciprocating jurisdiction for adjudication. Some reciprocating jurisdictions require the applicant first to obtain a provisional order from the Ontario Court of Justice, which is then forwarded to the foreign jurisdiction for confirmation. A support applicant who resides in a reciprocating jurisdiction outside Ontario may forward an application to the designated authority in the support applicant's jurisdiction, who will send it to the authority here. The authority in Ontario first verifies the respondent's residency in this province and then sends the application to the Ontario Court of Justice with notice to the respondent, who has the right to attend and contest the application. The Ontario Court of Justice shall apply the law of the jurisdiction in which the child resides to determine entitlement to child support, and if the child has no entitlement under that law, the court applies Ontario law to entitlement. The quantum is determined under Ontario law, and thus the guidelines apply. The ISOA does not constitute an exclusive code for interjurisdictional support proceedings. A parent may choose to proceed under domestic legislation where otherwise applicable. Also, provisional orders and confirmation hearings may be sought by parents seeking to vary support under the Divorce Act and the FLA 9. Ontario Disability Support Program Act, 1997. An adult child who has a disability, as defined within the scope of this legislation, may be eligible for income support from the provincial government. Any child support arrangement, particularly lump sums, should be considered in light of the availability of income support in a particular case and the restrictions under the legislation and its regulations.